I got my coffee. I'm ready to go. You know what time it is. Time for Monday Morning with Mo. Boop. Good morning, everybody. Welcome to another episode of Monday Morning with Mo. You know what time it is, 8 a.m. here on a beautiful Monday morning. Actually, it's freezing out there. Freezing for me, maybe not for you. But anyways, as always, we're here every Monday morning to answer your legal questions. So if you do have any of those, go ahead and shoot us an email, ask@dewitlaw.com, or leave us a voicemail, 407-536-6737. Hope you had a wonderful weekend. Off to a good start this morning. I know it's early. I know it's a little chilly out there. But hopefully you can get through the week just fine. Hopefully it warms up a little bit too. I don't know about you, but I'm not really a big fan of the cold weather. It's nice for like a day, but after that, it's not my thing. But that's me being a Floridian. So, anyways, let's jump right into it here. So first up this morning, we got Ryan. Ryan sent us a little email here. He says, hello, I am married to a foreign national. We met while I was living outside the country. My spouse has never lived or even been in the U.S. Due to the immigration process. She was never been to the U.S. due to the immigration process. Gotcha. Unfortunately, we did not make it as a couple. We were married in Colombia, but aside from the immigration paperwork, the U.S. and Florida government are not aware of our marriage. Do I need to file for divorce in Colombia? Does it matter as far as the U.S. since we never mixed assets? Can I be forced to divide any assets? Thank you, Ryan. All right, so I got a little bit of the sniffles this morning. A little bit of a unique situation. So you were married in Colombia. You never actually made it to the U.S., so I assume she's never lived here. You've never actually lived in the U.S. as husband and wife. So typically in Florida, in order for Florida to have jurisdiction, you have to live in the state for more than 6 months. One of the parties to the divorce has to be a resident of the state of Florida for 6 months prior to filing the petition. So it sounds like Ryan would probably qualify for that because I'm assuming, has probably lived here for more than 6 months. The complicated part becomes where his wife has lived. If his wife has never lived in Florida, theoretically Florida could have subject jurisdiction over the case because Ryan lives here. However, they wouldn't have personal jurisdiction over her. So, unless she were to agree to submit a divorce in Florida and agree to submit to personal jurisdiction, you may be stuck filing for the divorce in Colombia. Because basically, the wife here has never, according to the limited information I have from Ryan, has never lived in Florida, never submitted herself to jurisdiction in Florida, has never done anything to where the Florida courts would have power over her. So in other words, or another example would be, for instance, like with a business. So if I'm a business and I'm operating in Georgia, the Georgia courts would have jurisdiction over me because I'm agreeing to operate there. Same thing kind of applies here. The wife has never really done anything to where the Florida courts would have jurisdiction over her or any power over her. So that's where it becomes a little complicated. And obviously, then you're going into, if you do have to get a divorce in Colombia, then you're going into Colombian divorce laws, which obviously I have no clue what those are. Some of those countries, because we've actually dealt with this before, you may want to do a little research and see how legitimate the marriages are. I think it was Dominican Republic used to have a quickie marriage. And it was actually not legal. They didn't actually legally, they told you they married you, but they didn't go through the proper process. They didn't actually have the paperwork to do it. We had some cases there where basically the marriage is not there, but the divorce was filed in Florida, but it involved a Dominican Republic divorce. And the marriages weren't valid. So it became more of an annulment, or not an annulment, but just dividing assets at that point because the marriage was not legally valid, so there was no marriage to dissolve. So you may want to look at that, but unless your wife lived here for a period of time, or unless she did something to give the Florida courts jurisdiction over her, or unless she agrees to submit herself to jurisdiction, you may be stuck filing for divorce in Colombia. So best of luck, Ryan. If you need any help with that, just let me know. We can certainly try to guide you through that as much as possible. Sticker stuck on the back of my cup there. Can never never get in too much coffee in the morning. So, anyways, thank you for the question, Ryan. As always, if you guys have any legal questions, shoot us an email, askask@dewittlaw.com, or leave us a voicemail, 407-536-6737. That is what we are here for every Monday morning at 8 a.m. Next up, we have another email here. This email is from Johnny. Let me move this over to this screen so I can actually see it. All right. So Johnny says, the wife and I were having problems getting along. Lots of arguing, fighting, and just overall an unhealthy environment for our children. She told me to move out, and I did. Under the circumstances that if I got a new job and showed her I was, quote, ready to come home, end quote, she would let me come back. It has been 2.5 months now. She only lets me see the children whenever she wants. The point is I want to go home. We are still married. When she refinanced, she did not put me on the house, so it is hers. There's also never been any type of domestic disturbance. That's good. And he goes, okay. I just want to know what she could do if I move back in against her wishes. Thank you so much. All right. So let me get a little coffee before we tackle this one. So Johnny, I mean, from a legal standpoint, it's still your house. Even though she refinanced it, and it made the note and the deed may only be in her name, as long as the house was purchased during the marriage, it's still marital property. It's still your home as much as it is her home. And arguably, it's still your residence. Even though you moved out for a period of time, it's still probably your legal residence, because your leave of absence was only temporary. So if you want to know from a pure legal standpoint, can you move back in the home? Yeah, you probably can. Is it a good idea? No, it's probably not a good idea. The first thing here you say was an unhealthy environment for your children before. And so I think you want to give some strong consideration before you move back in against her wishes as to whether that's in the best interest of the children. The other thing I warn everybody about, anyone who's going through a divorce or a contentious relationship or a contentious breakup rather, is, all it takes is one party accusing the other party of domestic violence, and you're probably going to be arrested, and there's probably going to be a domestic violence injunction against you that's going to remove you from the house. So if it's going to be a hostile, contentious environment, it's probably in everyone's best interest, including your children, for you not to move back in that house. From a legal standpoint, can you do it? Yeah, you probably can. From a common sense standpoint, and from someone who's giving you actual good advice, hopefully, I would really advise against it. I think you can get yourself into a lot of trouble. I think you can hurt your kids. You can hurt your relationship with your kids. And it can be a bad situation overall. At this point, you probably want to talk to her about doing some sort of counseling if you guys are trying to stay together, or maybe start the divorce process if it's headed that way. Because I can understand it's certainly painful that she won't let you see your kids as much as you would like. But that being said, if you file for a divorce, a judge could order a time sharing schedule so you would have set time with your kids. But you certainly don't want to damage that relationship or give her any ammunition that she could use in a divorce if you move back in, things got contentious, things got hostile. So appreciate the question, Johnny. Again, if you need any help with that, give me a call, 866-CALL-MO. You can reach us anytime. If I'm not available, just leave a message. I'll get right back to you. So, and let them know that you saw us here. That way I'll know who I'm talking to. So, yeah, best of luck to you, Johnny. I know that's a tough situation. I know you want to go back home, but I think you want to be careful about that before you take any action, because I think it could get messy there. So, all right, last of the emails this morning, we got Jeannie. Jeannie says, I previously had a wage garnishment case, and they took a bunch of money out of my bank account. Now they sent a wage garnishment to my employer to garnish my wages, even though I already paid them. Excuse me. What can I do to stop them from continuing to take money from me? All right, so dealt with this a few times. So typically what happens in these garnishment cases is they get a judgment against you, and then they go in and they find what assets you have. And so if you have a bunch of money in a bank account, they garnish that first. They take all the money, but they still may be owed more money from the final judgment. So then they're going to garnish your wages. Then they may garnish your other bank accounts. They may go back and garnish your bank account again if you put more money into it. So, in my experience, the best thing you can do is reach out to the person. If they've already got a judgment against you, it's too late to defend it at this point because that ship has sailed. Is you have to reach out to the attorney who's handling the garnishment case, who has the judgment against you, and try to negotiate something, because otherwise this just goes on forever. They keep taking money from you. It's a surprise. Your bank account gets wiped out. You can't pay your rent. You can't pay your mortgage, whatever it may be. So either you need to reach out to them and try to talk to them, or have an attorney do it for you. But the reason they keep taking money from you is because the judgment is for more money than they got out of your bank account. You still owe them more money. A lot of times, the attorneys and these people don't want to be chasing you around all the time. So if you work with them, sometimes you can work out some sort of payment plan or something like that to try to get rid of this. But otherwise, this is just going to go on forever. So that's why you keep getting these garnishments. That's why they're trying to garnish your wages now. Definitely reach out to someone. There's also it's good to know there's certain exemptions where they can't garnish a certain percentage of your wages. And if you have a head of household exemption, that may be another exemption to where they can't garnish your wages. So definitely talk to an attorney about that, depending on your situation, so you know whether they're properly garnishing your wages or not, and whether there's any exemptions that you can put into place to stop them from garnishing your wages. So very important to know that. So if you have any more questions about that, Jeannie, give me a call at the office, 866-CALL-MO. If you guys have any legal questions, shoot us an email, ask@dewittlaw.com. Leave us a voicemail. That is the voicemail line for this show, 407-536-6737. You can leave a voicemail there, and then we'll answer it right on the show here. So that is what we are here for. Let's take a look. I think we got one voicemail here. Let me track that down. Make sure we got that set up to actually play. Hopefully this works. Let's give it a whirl.
Well, hello. I was calling with a question regarding a legal matter that dates back over 20 years in a criminal matter whereby it was found that the reason for arrest was false, and there were some lies and things that made it down on police reports which never occurred. And as a result, the judge told both the state and the defense to come up with some sort of agreement that he wasn't going to go for any level of incarceration. And so it was decided to go for downward departure and a probationary period to be implemented. My question is there any relief due to the fact that it was supposed to be a downward departure hearing and sentence, and now some 20 plus years later, changes to various laws and such have essentially tightened the noose around my neck, and this loom or cloud that looms over me should never have remained after the period which the lawyer that represented me, he basically essentially was working for the state as well, it seems. So, I mean, there was no representation there. I don't know if that goes back to ineffective counsel, or maybe it was even more grossly negligent than so.
All right. So interesting voicemail there. Hard to kind of narrow down the question exactly, but it sounds like basically you pled out to a charge about 20 years ago. It's now had some adverse consequences to you in some way. And now you want to know basically if there's any way to challenge it, whether you could bring up ineffective assistance of counsel or something along those lines. I don't know offhand what the time limit, or if there is a time limit on ineffective assistance of counsel for criminal cases off the top of my head. But I'll say in general, anything over 20 years is usually going to be pretty tough to get overturned, to raise at this point in time. In the civil world, in civil judgments, you typically have a year to try to set aside a judgment if there was, fraud, mistake, something along those lines. Criminal is a different animal, but I'm going to guess, now that 20 years has passed, it's probably going to be pretty difficult to raise those issues. And who knows even if the transcripts are still available after 20 years of what happened at that plea hearing, because I would think you would certainly at least need those to lay the foundation for ineffective assistance of counsel to show the court why it was ineffective at that time. So 20 years later, probably not a whole lot you can do about it. I don't know if you may qualify for an expungement or sealing of the charges, if that would help the situation as to why it's causing you some difficulty. But otherwise, probably not a whole lot you can do there. So always appreciate the voicemail. Always appreciate the questions. As always, if you're still watching to this point of the show, I certainly do appreciate you. Have a wonderful week. Have a wonderful morning. Stay warm out there. Give us a call with all your legal questions, and we will see you next week, Monday morning at 8 a.m. for another episode of Monday Morning with Mo. Have a great week, everybody.